Our first attempt in court was back in December. We showed up in there as living beneficiaries of our trusts. That's how we stated our position. We didn't answer to our last names, and we didn't stand or sit for the court, and the judge kept trying to get his jurisdiction on us, so to speak, and we just kept politely refusing, but standing our ground, and basically saying stuff like, I'm here as the living beneficiary of the estate trust being administered here today, and I'm here to settle the account in full, and things like that. So we were quickly getting the judge quite heated in that first meeting, and he quite had enough of us and threw us out. Well, seeing how you're not the people I'm looking for, then you need to get out of my courtroom then. Escort them out of my courtroom. I don't need them here. So off we went.
Let me just stop a second. Where did you learn that decorum style? Just over the years, like listening to talk shows or YouTube? Where did you pick that up?
Well, has been over the years, listening to like Dean Clifford, through Divine Providence with James McBride, with Peter and Michael, and so we've been definitely doing a lot of different types of research. There's been some YouTube videos. There's been, definitely a lot of different avenues over the course of the past couple of years.
But what I was trying to say, was my style just a lot simpler, like more normal looking that you see?
Definitely straight to the point, very simplified, like it takes all the fluff out of the...
Yeah, the uppercase, lowercase, none of that stuff matters, nonsense, right?
That's right, just don't have to tear your hair out over how you're writing something. Yeah. Just, I, woman, you take stuff, give it back. Just real simple. So, caveman style, like you're speaking to kids.
Yeah, save that for the end, but keep going, yeah, because like you just said, your whole lawsuit.
So essentially, we definitely went through the ringer with being elaborate and fancy in our language, and we did use a lot of Latin terms and a lot of their own rules and their own terminology to try to kind of help our way along somehow, to show them how smart we were, I guess. So we ended up in court again, and we kind of took a little bit more fluff out, but we were still a little bit elaborate. We were still living beneficiaries, and there were still trusts involved, but we weren't asking for any bonds anymore. No bid bonds, no performance bonds, no hazard bonds, no surety bonds. And we just kind of kept it a little shorter, and we would get a little more respect, a little more ears opened up, a little more attitude change towards us, like, instead of being all mocking who we were and oh, look at these two idiots coming in here with their fancy talk and their crazy talk. Nobody knows what they're talking about. Nobody knows what they're saying. But, they're being very wary of us still. So when we started to learn on your stuff, Karl, we had gone through several avenues already, and everything was so convoluted and complicated between the grammar of what you were writing down and what you were saying in court, and when we finally got upon your stuff, it really just made it a lot more simple, a lot more to the point. We had heard your name a few times thrown around, and that's kind of what finally led us to you. We were like, okay, well, let's hear more about this Karl and what he's got to say, because, this stuff seems to be all fine and dandy, and it seems to be scaring them a little bit, but it doesn't seem to be getting us any further along. So one of the last hearings we had, a lot of our information was based on Dean Clifford. This was before we started our hearings with you. And we quoted a lot of the charter, and so we were getting a bit closer and a little more, getting more simplified, but we were still kind of playing in their sandbox. So finally, when we started to use your stuff, we were going in with our claims. They were fairly large. One was 13 pages and the other one was 9. So we hadn't quite simplified it enough, but it did get a judge's attention. So it did open up a court for us so that we could talk to the judge and everything was still, we still had living beneficiary status in there, and our Jonathan Joseph of the House Little and things like that in there, and it's still quite wordy.
Let me just jump in for 2 seconds, because this is what I tell people all the time, because two of my friends are judges, and they have been asked to sit in on civil hearings. I'm telling you, when you send a large piece of paper to the judge, he's going to hand it to a subordinate. He's going to hand it to a clerk to read and tell him, hey, look, highlight and tell me what these people are saying. I don't got time for this stuff. So this is what I do a lot of times when you folks send me really long emails. I say, Greg is really interested in deciphering this stuff and trying to figure out, researching this stuff. I'll just take your emails immediately and send them right to Greg, and Greg will start breaking them apart. So that's what I'm basically telling you what a judge does. If you send him eventually she's going to tell you where she basically just sent the judge 2 or 3 sentences. He'll read it. He'll be like, I can handle this. So, okay. So like you said, I'm trying to remember. What happened was you tried to do a writ of habeas corpus, but I told you don't say writ of habeas corpus. I tried to keep pounding at you people saying restoration of property.
That's right.
Okay, that's the point where we're basically at now, folks. She's starting to get to the point where I was saying we want the restoration of property, not habeas corpus, because that's Latin again. And if you write Latin, they could write every freaking thing in Latin if they feel like it. If you want to play their game, they could play their game. You calling the tune, you better be careful when you say habeas corpus. You want to put on a big boy pants, well, you better know how to speak Latin from beginning to end. So what the point that you're at now is where you got in touch with me, I guess, about 2 weeks ago when you did your restoration of property.
That's right.
And it got down a lot simpler. I think we got it down to 2-3 pages tops.
Yeah, it was about that, and that was including all their silly jargon that I had to put in there as well, with notifying the other parties. And so basically it was, these people are administrating my property unlawfully and without rights and against my wishes. They are in possession of my property without rights and against my wishes, and they're detaining my property without rights and against my wishes.
So when you handed that to the court clerk, you said the clerk of the court turned around and went and found the court clerk, and then she went around and found the judge, and there was some certain words in there that they did not like.
That's right. They really did not like the word property. They were cringing at that word like I had just used a big profanity in the middle of a church.
Why don't they like the word property? What have you learned?
From what I gather and what I've learned now, they don't like the word property because they have no jurisdiction over it. They have no authority over it whatsoever. But if I wanted to call them children, then they can start slapping statutes and codes and rights to it.
You're using their definitions. You're using their words.
Yeah, exactly. So they don't like that. They didn't like the word property at all. So we kind of appeased the judge at the time, let him kind of scratch out the word property and put in children. And then before anybody responded to our claim, we resubmitted an amendment to it and changed everything back to property.
That's right, because you can make an amendment without leave of court. Until somebody answers, though, then you have to leave a court, which you basically, your goose is cooked, because nobody's going to agree to allow you to make amendment to your claim. And you're going to dive and live by what you said the first time. But go ahead, you're doing good.
So the only pitfall to that was the return of property was being filed into their case instead of for our own. So it kind of set us up for failure right from the beginning. When we went in for that hearing for the habeas corpus or for the return of property, they heard us out. They read all of our documents on the record. They understood that we were coming in there as a man and woman and that we didn't, recognize or understand their legalese and their codes and statutes. And it went on for quite a while, and it was starting to look good for a while, and then all of a sudden it kind of took a spin, and he just spit out some code or statute about the Child Welfare Act and then denied our return of property and left the courtroom. And we were just kind of like, wow, whoops, what just happened there? So, but we kind of knew because, of course, that it was filed into their case that we were likely going to be denied in the first place. So that was the first time they denied our claim.
Because you did not have a proper claim before the court yet at that time, had you?
No.
You didn't pay the filing fee for like a claim. You hadn't done any of that stuff yet, right?
That's right.
So see, folks, you still have to operate under their rules. So under their rules, there's no such thing as habeas corpus. Under their rules, there's no such thing as a restoration of property. So there you go. That answers your folks' question if you ever say, well, hey, this man's in jail for this X, Y, and Z. How about we file over to habeas corpus? Well, she just showed you that it's not going to work if you're filing under their case number. So there you go. Then we explained that you're going to have to make your own case number, and you're going to have to make your own claim.
That's right. So then that brought us to making that our own claim and starting our own case. So this was our second try at trying to submit a claim for our own case, and we were still meeting roadblocks. We were guided by the court clerk who's saying, well, you know, it wasn't exactly, there was some information missing about the amount of time that we needed to provide the other party to respond and stuff and to bring forth their claim. And so we're like, okay, well, we'll be reasonable then, we'll give them enough time, so to speak. And so, but we're not changing, you know, our claim. We're just gonna change the amount, add the time that they need. You know, instead of come to the courtroom in 2 days, come to the courtroom in 20 days, in our court. So we sent this to the clerk and said, you know, have a look at it now, and when you file it, you know, give us a number. So she writes us back. She sends me back the claim, and she has her edits all over it, and she even put her name to it.
Yeah, she actually signed it. She actually took out certain words, like the word at.
That's right.
You know, what is it, at the court of the Queen's Bench to in the court of the Queen's Bench. And if you listen to their shows, I'm not going to explain it now, but at the Queen's Bench is incredibly different than in the Queen's Bench. So even the very first word, the lady crossed out. So I don't want to hear anybody tell me, well, oh no, don't be so technical on the words. Don't be like that. You know, the complaint, claim, it's the same thing. They understand, and they say, well, they say Kearns versus Kearns, whatever, you know, 1967, that the court isn't supposed to is supposed to allow a lay litigant a lot of room when he uses words incorrectly. And you know, I know by what you've seen with the court clerk, she got very upset by saying that somebody did you wrong. She's like, no, you call them defendants. You don't say they did you wrong. You say, you know, they are defendants, because there's a huge difference between being a defendant and doing something wrong. Because if you're a defendant, there's always some sort of like, well, let's be reasonable about this, like negligence. Maybe they thought they were doing the right thing. Maybe they were operating under a code. Maybe they thought, you know, they had a plausible deniability. Maybe. And like I said, like I'm a dad like that. And all I want to know from you, kid, is did you do wrong? Yes or no? All I want to hear from you is yes or no. Because once you say you did it wrong, that's it. The conversation stops. I don't care what you did wrong. Well, Susie told me to do it, and they were doing it too. Look. Did you or did you not do wrong? Yes or no? It's like it's black and white. It's the death penalty. I don't care why you did it wrong. I'm not here to negotiate. I just want to know, did you do me wrong? Yes or no? So this is how we were trying to get Jesse's thing down. And like the final draft she sent me, and I realized I just got to, you know, like bite the bullet and write this thing real quick, because she's like, I got to get this thing now. I got a long ride. It's almost 5 o'clock. So I just edited out all the stuff. She did a really good job. She was tenacious. She was really hardworking. She really was diligent. She really was trying. But I realized she was up against the wall. So then I just cut it all the fluff out. But you guys have to learn all the fluff. You really do, to try to get a grasp of a single sentence. And then it will make a lot more sense. But you can't just write single sentences and think that's going to be the end of the war. You know, this is just a battle that they're starting. And if they don't move out of New Brunswick, the battle could keep going on.
Exactly.
So then, okay, we got to the point where you gave them a claim, and they were trying their best to not accept the claim, right?
That's right. She sent it back with all her edits, you know, changed our word lawful back to legal, changed, you know, said court. She took that out of there. She took the Jacinthe court right out of there. She took, she changed the word at to in. She definitely did a piece of work. It was like a Picasso. And she sent it back to me, and she said, make all these changes, and then I can accept it. So I then took her copy that she sent me and forwarded it to the chief judge, David Smith, I called him, and I wrote him a nice little letter. And I basically outlined, I believe we read that letter on one of the previous calls, but I basically forwarded him that stuff and asked him to, bring forth the laws, show me the laws that say that, as a woman, I guess is the letter, is there a law that states that there is nowhere in Canada for a man or woman not fluent in legalese terms of your legal society to move a claim and or evoke their rights to a trial by jury?
What she basically did, folks, what we were basically trying to get her to do, was tell the judge there's an 800-pound gorilla in the court, and he's only 400 pounds. So she's relying on the fact that Canada, or that part of Canada where she lives or resides, operates under the common law, is the supreme procedure or the law of that province is common law. So she was telling me, that's lovely that you folks are trying to drag me into some code world, but this ain't France, this ain't Quebec. I'm still in a common law land, and she made a nice simple letter to the judge. She didn't put in all kinds of Supreme Court rulings or Parliament rulings. She didn't use the Charter of Canada, the Canada Charter in 1982. She didn't use Section 1 or Section 33. You didn't use any of that stuff, did you?
Nope, not at all.
There you go, folks. See, that way he can't answer. What she's doing is making him the defendant. He's got to curl up in a corner. He's got to take a beating. So now he sees that there's an 800-pound gorilla on the horizon, and she's not backing down. She's not going to play this game with these people. So what day was that, like a Wednesday, Thursday, Friday last week?
That was, I believe, Tuesday of last week.
Alrighty. And then you were getting some sort of a hearing coming up this Monday you had, right?
That's right. At the same time as I sent that letter to the judge, we went into town again and we decided to put in a request just to see if we could buy some more time for ourselves to submit our claim.
And what did I say about that?
You basically said, yeah, it's not going to happen, and you should just be ready to go anyway.
I was trying to stay as calm as I could, but I was extremely upset. It's like, you take your hat off if you bring a hat into court and throw it on the ground. Say, I want a damn trial. I want it now. You get it on. Let's get it on. Rock and roll. Let's do this. And you were actually trying to see, because they could smell fear.
Yeah. And
even though you're terrified, take that hat off and throw it on the floor and say, delay of time, stay the proceeding. Oh, no, I'm good to go. Rock and roll. Let's do this. And, man, it'll scare them to the core. But that's okay. This is your first turn. Well, you know what I'm saying. This is the first time dealing with my style.
That's right.
Okay, she tried to ask for a stay, and then the judge said what?
Well, the judge was like, well, what have you been doing for the last 5 months, and why do you need more time, kind of thing. And, I said, well, I've been making all these attempts to settle the matter in private with CPS, but they insist on having a trial, and we've been making many attempts to file a lawful claim against those who robbed me of my property and have an order signed and sealed by the court clerk to have my property returned, but we keep being interfered with by the judges and the court clerks who believe they have the right to modify my claim and judge whether it has any merit. So, so CPS still wants to have their trial, so I'll need more time to gather evidence and witnesses to become available, kind of thing, right? So then the judge looks at me and he's like, well, are you going to get a lawyer? And I was like, well, no, of course not. So you're insisting on still presenting yourself? Yeah, definitely. So he's like, well, then are you going to pick up the full disclosure then? And I said, well, I can't see how reading the excuses that my robbers used to justify their robbery has anything to do with me proving that they had a right to rob me of my property.
There you go, folks. I don't know if you understood what you just did. That was the whole lawsuit. It was a trespass. That was the nature, and the characteristic was robbery. And that was the whole lawsuit. So when somebody does you wrong, you don't give a rat's, you don't care why they robbed you, that he had a bad upbringing, that his mommy didn't hug him, mommy didn't kiss him. All you want to know is, did you rob me of my property? Did you physically take that by force in front of me so that I could point across this courtroom and say, I saw her touch my property. She had no right to touch my property. I demand for her to come forth now in this court and tell this court where she has the right to touch somebody else's property without their consent. So then what happened when, okay, go ahead and tell, because you said to them, you asked that you said that now you want the lady's testimony stricken from the record, or you objected. How did you phrase that then after you explained to the judge, I don't care why the robber robbed me?
Nobody had gone up to testify yet. This was still just hearing my request for more time. So the trial was just on hold while they were listening to my plea, basically, to ask for more time. So when I told them basically, I didn't have any interest in their justifications for robbing me, he says, well, you insist that you don't understand our language and our rules in here and our statutes, and yet you still refuse to get a lawyer. So you're not even trying to help yourself. I don't even understand it, and you won't even get the disclosure, so I can't see how giving you more time is going to change anything. So I'm not going to grant you an adjournment, and we're just going to go ahead with this trial.
So you got a little nervous, though, when he said, we're not giving you more time, right?
Yes, I definitely had that little twinge of anxiety kind of perk up, but I kind of anticipated that we weren't going to get more time, so we brought in our external hard drive with family photos and videos, information about what they were doing to our children, recordings of their life, and we had a few things up our sleeve anyway for just in case.
Right, but okay, let me stop you right there for a second, because I'll explain to you folks one day what agency means, and when you're going in an administrative hearing. I don't care if you have the Pope and Jesus Christ on your side. I am telling you, I don't care what proof you have. I don't care what thing they're committing perjury on their side. I don't care. The judge he has no choice. They always give it to the agency that's 51% and you 49. I don't care if those people are flat out lying on a witness stand and you have Jesus on your side to prove they're lying. The judge has to accept the word of an agency because an agency, in his mind, is infallible. It's not capable of being lying. So when the DHL workers are up there, it's not Susie DHL worker, it's DHL worker. And they don't have the capacity to commit fraud. It's incredible how agency is in administrative court. Because like I said to you folks on my thing, the judge let me talk for 7 hours. And he said to me, Karl, you do know the concept of agency. And no matter what you say, until that side says that they're lying, I don't care how much proof you show me. I said, yeah, I know, Judge. I said, but it feels cathartic. Thank you for letting me get it out. And he says, look, Karl, let me put the final judgment in. I'll meet you out in the hallway. I know what the state did to you. I know they took you. I know exactly how they did it. I'll show you how to overturn me. I'll show you how to file an appeal. And I'll show you how to get a copy of that contract that they won't provide. So this is what I try to say, folks. Even though, like Jesse was saying, I did backup. And I made sure I had videos and photographs. And I brought the Pope and Jesus. And I brought the Queen of England there to support my claim. When it's an administration agency hearing, I'm telling you, I'll email you folks, what an administrative hearing is all about. Because when it's just, say me and Jesse sued each other. Say Jesse said she'll pay me $20,000 to help her get back her kids. And then I said, okay. And I go to court. It's he said, she said. It's 50-50. And who's ever moving that claim is basically going to lose because it's 50-50. Unless I get in front of a jury. If I get in front of the jury, then the jury might feel bad for me. But that's why I tell everybody about that Judge Judy show, where Judge Judy said, well, I know this black guy's prison record. And I know you bus full of nuns and orphans. I know this man knocked your bumper off. But he has just as much equal standing in court as you do, regardless of all the evidence, all the orphans she brought in. She brought in nuns. And Judge Judy's like, I know this guy's lying through his teeth and he's laughing at us right now, but he knows the law. It doesn't matter. Unless you nuns brought this in front of a jury, I can't do anything. I'm just a judge. I got to abide by the letter, the black, white letter of the law. So see, like I said, Jesse, even though you had the backup of all the pictures, and even though you could prove that they committed perjury and everything else, the judge said that to me. He said, Karl, I know he's lying through his teeth. I know there's no contract. Karl, you and I and him and your counsel, we went through this file for hours. We can't find it. And the one we did find is a total joke. He says, but as long as the agency still says that there's a legitimate contract there between the parties, there's nothing I can do, Karl. You've got to prove they're lying. Good luck with that. The stage is yours. Take it, Karl. So I took it from 9 o'clock until about 4 o'clock in the afternoon, and the judge said, come on, Karl. Let's just wrap this up. Come on, just throw in a towel. He said, oh, no, I'm going to fight. I'm going to win. He says, just wrap this up, Karl. This was like 5 years ago. So I learned a lot since then. So like I said, that's what you folks would have done. So it's nice that Jesse brought all those hard drives and family photos and everybody to say, the other side's lying and perjury and everything else, but it's not going to carry the day. So go ahead and continue though from there, Jesse, that you said you were thinking about maybe this would have helped.
Yeah, so of course we recessed after that once they denied us for more time and got prepared for the trial to begin. During those few minutes that we spoke to our Exes lawyers and to the Crown Counsel. And
the folks don't know your Exes showed up. That you were two separate couples. That you're Jesse and Jonathan. There's 5 kids altogether, 2, and 1. So the other 2 are for another ex-husband, ex-wife, and 1 is theirs jointly. So they
actually, Karl.
What's that?
4 kids. Sorry.
Sorry about that. Well, whatever. Well, I'm just okay. That's good. You've corrected. But what I'm saying is, they brought the Exes in. So I guess what they were trying to do was trying to get the Exes to take custody if you guys failed. Was that the purpose of bringing the Exes?
Right. Actually, the purpose of bringing the Exes in, they were trying to divide and conquer everybody. They lied to the Exes. They lied to my fiance's ex, saying that she was going to definitely get custody of the kids, and they set her up with an apartment that she couldn't afford otherwise on her own, and got her all ready. And they told my ex that they were going for permanent guardianship of the kids, and they were trying to terminate our parental rights, and he had to step in, otherwise Braden was going to be, or his son was going to be lost in the system for forever, and nothing that could be done to save him, and it was just ridiculous, the lies that were spreading.
The reason why you weren't going to be able to save them, because believe it or not, they were telling you the truth. There was no way to save them if you folks stayed on the administrative side of the court. You would have never, if everything they told you, Exes, would have totally came true. You say, well, do you believe it would have came true?
Oh, yeah. If we wouldn't have done it properly, yeah.
I've seen this happen to hundreds, thousands of people, man. Exactly what Jesse's telling you. They're going to get the Exes involved. And they're going to tell the Exes, we're going to give you a college education. We'll provide you free medical, free transportation, free everything. Just conquer, just go after the other side and just say they're a bunch of potheads, a bunch of drunks, a bunch of wackadoos who believe in hippie deeds and massage therapy nonsense. Just discredit these other people, and we'll work it so you get the kids, and they'll pay you child support for the next 18 years. So that's basically what they tried to do.
Exactly what they tried to do. So it didn't work. It worked at first. We were a bit divided, but we came together. Some lies came out. They found out that they heard some of our recordings and whatnot, and they were like, "Oh, wow!" So we all started talking.
What recordings?
Recordings from CPS, the workers lying about the situations and lying about abuse and just all their conniving basically caught on tape.
Where did they get the recordings from?
From us. We recorded all our interactions with them.
Oh, good. See, folks, this is a good thing to do too. This is what I do too. I record every single thing when I'm talking to the other side, and I don't want to get into semantics like, well, you got to look the other side, know you're recording them. Yeah, good. You know what? Sue me. I'm going to get on you that you're doing me wrong.
Exactly. And
I think
we got the dirt all right.
That's right.
And they knew we had that dirt, and we brought it forward, and they were very unhappy about that. And they said that they knew that we were recording them, but that they didn't consent to being recorded. And
right.
We're like, well, we don't care.
What I'm saying on the administrative side, the judge would have thrown that all out. Okay? But like I try to say, what's going on, folks, is the judge realizes you have a claim before this court, and somebody's going to have to answer this claim on behalf of the Crown within the next couple of days. So he's got this trigger pointed at him saying, let's see how this lady handles herself in open court. Because if she could hold open court here and say the certain magic words here, we're in big trouble when her claim finally comes before the court. Do you see what I'm saying? I know what the judge was doing. He was testing you out to see how strong you would stand in court. And were you confident that you were going to be convinced like a jury? If you finally got your jury trial in 20 days, how were you going to be able to do it? And then he said, I guarantee this judge was saying she's going to win. She's good. She's no dummy here, man. I don't care what these social workers are saying about this woman. She's going to kick your butt in front of a jury.
Yeah.
Okay, so go ahead. You can keep talking about So when did you go ask them to tell the lady, we want this lady's testimony stricken from the record, and why did you say that to them?
Well, they called the first witness at the beginning of the trial, and this was after we spoke to our Exes lawyers and stuff, and during the recess between asking for more time and when the trial began, we actually brought an offer to the Crown Counsel to ask CPS to settle once again in private. Listen, just give us back our kids. Let's stop these shenanigans. You know, we've been trying this for months, and we just one last attempt before the trial starts. Let's see if they'll settle.
So that was basically like line 4 on your claim that I'll forgive you your trespass. You know, you basically made that last offer, right?
Exactly. Like, you know, let's just let bygones be bygones. They're like, you know, this is just business here. Give us back our children, please. You know.
What the judge and everybody's doing is they have a copy of your claim, and they're seeing that you already mentioned the word robbery to the judge. Mm-hmm. Now you're whipping out line 4, saying if you turn back my children within X amount of days, I'll forgive you of your trespass against our property as we would want you to forgive us of your trespass against us. So they see that you're going along. It's only 4 lines that you have in your whole freaking lawsuit, and you already got 2 of them done.
Yeah.
So these people are realizing you are doing the honorable thing. You are bringing up your claim as many times as you can say it. So they know there's no doubt about it, that this is your word, this is your claim, you're standing by it, and you're not going to be tricked and confused into saying anything else but.
Exactly.
All right, so keep going. You're doing good.
So, of course, the Crown Counsel came back, pulling his hair out, saying, no, CPS, I went to bring your offer to the workers, and they refused. They want to proceed with the trial.
Because they had a dynamite case, right?
They had a dynamite case, ironclad.
And you're going down hard, so you might as well give up.
Exactly.
Okay.
So they called their first witness, which was one of the foster parents, one of the caregivers. She gets up there, and the Crown Counsel gets to interview her first. Our Exes lawyers get to cross-examine her.
Okay, tell them why. Tell them, okay, this is maybe nobody's been to court before. Attorneys always get to go first. You get treated like dirt. You get at the end of the line. So the Crown gets to go first, yay. And then everybody else who paid for attorney, had an attorney, they go second or third. And you guys got stuck at the end of the line, right?
That's right. Although I did kind of enjoy being at the end of the line because it got me to hear a lot of stuff that she was saying and pick out a lot of things and kind of work off the questions that everybody else was asking. So when she gave her testimony, there were things that didn't match up and just things that she kept contradicting. So I picked on those things, and I picked on her testimony, and I picked it apart. And she got all flustered and angry up on the stand, and finally she's like, oh, well, fine, I could have just missed something, she said, you know, all angry, and the judge had to stop the trial.
See what's going on, folks. This judge, he's witnessing what's going on. Not today, at that hearing. He was judging what's going to happen if this lady goes through with a gazillion-dollar lawsuit in a week or 2 from now. This lady's going to destroy the Crown on the witness stand if she gets a common law trial by jury. So see, this is what they're doing. The judge is testing this out because they all know there's this ridiculous gorilla that you filed a couple of days earlier. So go ahead.
So yeah, you know, after picking her testimony apart and making her contradict herself a lot, I basically said that she, you know, I attacked her credibility and said that her testimony wasn't very reliable then if she can't even remember, recollect her facts correctly and recognize what she wrote in her affidavit versus what actually happened. So the judge had to stop the trial and have a trial within a trial. They called it a voir dire. To decide whether that part of her testimony was going to be admissible into the main trial. So they recessed for that and decided to deliberate on that for a while. And
what's going on? What's going on is it's not just what's going on right then and there. Like I said, they got the wheels grinding under there. They know what's going to happen next if you keep going with this. Not that you're going to smash them in an administrative hearing because you're never going to win. You're not going to win an administrative hearing. I don't care who you are. I tried it. It ain't going to work. I showed him perjury. Me and the judge, we went through 500 pages in a case file in open court. We found a contract. It had nothing to do with us. And so the judge clearly said, I know what the state did to you. I know how they took your kid. I know exactly what they did. But until somebody on that side actually stands up and says, we're guilty, there's nothing I could do. because my hands are tied by the rules that are before the court. So see, this is what I'm trying to say, folks. Even though that Jesse could bash these people in with I bashed the people in too. It did me absolutely no good until I learned how to, like I said, move something in common law. Administrative hearings, you'll be so frustrated, so angry, and so upset, because they keep ruling against you, And you say, this makes no sense. We proved beyond a shadow of doubt. This judge has got to be blind. And no, his hands are tied. It's not that he's blind. His hands are tied. And like I said, if you guys really want to know the rules of agency, I'll send you everything I found over the years that proves that unless they stand up and scream that they're guilty, you're out of luck. So you basically said that they said, you know what, we're gonna see if we should accept this lady's testimony or not, right?
That's right.
Okay.
So they definitely they ruled that her testimony was inadmissible, and it really ticked off the CPS workers and whatnot, and the foster mom just left out of that courtroom all in a huff, just couldn't believe what had happened.
The reason why she can't believe it happened is because she's lied countless times on that stand, and it has never happened that way. I'm telling you, they just flat out lie, and they're always covered, and the Crown always says, or the state attorney says, don't worry, just make it good. The judge is in our pocket. Everything's on our side. You just rip it out. Nobody cares what this lady's got to say anyway. It's a scam. Anybody who's been like this the first time you've had your kids taken, right?
Yes.
Okay, see, if you've seen the women on this call or who will listen to this call, she says, oh, that's exactly what happened. And then still judge ruled against us. Oh, my God. I'm telling you, unless they think that there's a lawsuit, a hammer going to drop down on their head, and you're relying on something other than going through their rules to drop the hammer on their head, they don't care how bad they lie in open court. They don't care. So you said that, like I said, you might think that it was your great interrogation skills or your great Perry Mason skills cross-examining them in open court. They don't care. They lie a million times.
They're worried about that claim hanging in the background.
They know they're going to get a whooping because you're not incompetent. And when you move your claim, you're not going to need an attorney in common law because, see, if you bring an attorney to move your claim in common law, they can. So you're going to actually be able to move a jury to find in your behalf, to render a verdict, to give you some money. And nobody's going to appear on their side because an attorney's going to try to speak, and I want to explain to you real quick how to do that. You're going to knock them out, right? You already know how to do that. So there you go. Keep going. The lady couldn't believe this is the first time ever she gets thrown off the bench and says everything she said is garbage because Jesse's this master, brilliant Perry Mason, and she busted right open. No, they knew what's going on.
No, they definitely felt the pinchers tightening around them, I think.
But you're sharp. But you're quick. If you were not as sharp and as quick as you were, they wouldn't be that afraid of you. They'd say, she's not going to be able to hold her own in court. So go ahead. What happened next? Then they made the day off. Well,
the Crown. It was the day was quite long, and they had to adjourn till the next morning, right? So the Crown comes to tell us, listen, he's pulling his hair out and everything, and he's got I've got all these affidavits, but I can't bring all the witnesses in for all of these affidavits. I hope that's fine. I'm pretty sure you're okay with that. You probably don't want to have that many people come in and testify against you anyway. And we said, well, of course we want every single one of those people to be brought in here. We want to question every last one of them. We'll crucify all of them.
Right. He tried to make it seem like, well, come on, you don't want to bash fest. You just we'll be merciful on you. How many did they say they were going to bring in?
Well, they said that out of the 20 affidavits, they were going to only have 10. So we said, we want all 20, or pull out the affidavits.
See what I'm trying to say, folks, is they had no intention on hugging this woman and kumbaya her. No. They were going to push her with 20 people and just pound her into the ground.
That's right.
But she demanded that every single person that said that she did wrong better appear and put their hand on a Bible, and she's going to hold them liable for what they're saying, their false testimony, their false claims. At this point, they're acting as state actors, and they're not liable for their claims. You're going to drag them into open court, and you're going to make them liable.
That's right.
That's what you're doing. You're setting them up to be sued.
That's right.
There you go.
Witnesses were dropping like flies then all of a sudden. Nobody wanted to come up and testify anymore, and they were pulling all their affidavits, and they're like, yeah, no, we're not coming to court. We'll gladly pull our affidavit. We don't want to have anything to do with this anymore.
Yeah, the first time in New Brunswick history, everybody just drops like flies.
Yeah.
There you go. Then what happens?
So we adjourned till the following morning. The next morning arrives, and this time we have even more stacks of our what we think is wonderful evidence for their expert witnesses, their doctors, who are poisoning our children with their soy and their and whatnot. So we brought in all our evidence to kind of destroy their.
Yeah, let me put a pause on there for a second, folks. Don't do that. Don't do that. Don't. I mean, what she's doing is wonderful and lovely to protect the children and stuff. But luckily, she didn't have to present all that stuff to court. You want to get out of their jurisdiction as fast as you can. You basically say you don't want to cross-examine them. You don't want to present your evidence at this time. You wait for your trial. You wait for the money trial. You wait for the trial where you're going to get compensation for damages, where you want the jury to believe your stuff. Right now, you just have a man in a black robe. He couldn't care less. He's just following the black and white letter for the greater good. If there's something in Canada that your province said that we're going to put fluoride in the water, he doesn't care your personal opinion. He's just going to, if it was based upon a consensus by the elders of the province that we're going to put dynamite in the water, he doesn't care what your belief is. But the jury's going to care.
That's right.
So as I'm trying to say, folks, when you're in front of the man with the black robe, don't try to convince him with all this heartfelt stuff like GMO foods. He doesn't care. He does not care. All he wants to know is the black and white letter of the law. All you want to say is when that person gets on a witness stand and say, who gave you the right to touch my property? Can you show me the delegation of authority? Can you show me where you have that right to administrate my property? Can you just show me? And the lady will be like, well, no, I can't. Well, there you go. Anything she has to say then is inadmissible. But you did the really long way to doing it. I would have just called you over and said, hey, just hit it with this sentence. Let's go home. But thank God they were merciful. What happened on Tuesday then? You were getting ready with this inch-thick
Yeah,
stuff.
I was getting ready with this like inch-thick stack of our property and what they were doing to them, and while in their custody. And we gave a copy to the prosecutor and to the lawyers for our exes. And after about 30 minutes or so, the Crown comes back and announces that CPS wanted to settle and give back the kids. So definitely at some point something came down the pipes. Like, we were like the chief judge still has our letter. The claim is still hanging in the balance. And the Crown Counsel came to us and he said, we presented ourselves. We never got a lawyer. And the Crown Counsel came to us and he's like, okay, are you recording me right now? Because I know you're always recording. And we said, no, we're not. And of course, we weren't able to record any of that. And the Crown Counsel says, okay, well, off the record, these CPS people are scared poopless of you. And they don't want to have anything more to do with this.
What did you?
They're scared poopless of us. I don't want to say the other word.
Oh, you can say it, man. Don't say exactly what they said. That's okay. That's
fine. They said these CPS workers are scared shitless of you.
Now, when you started this 4 months ago, listening to all this other crazy stuff, they basically laughed at you and threw you out of the court, right?
Yeah.
There you go, folks. That's what I'm trying to say. One sentence done. Now, what was the one sentence you told them? What was your lawsuit? Go ahead.
Who gave you the right to administrate my property, basically? What right do you have? What authority do you have to administrate my property?
I, a woman.
Oh, that part. Oh, yeah. I, woman, my stuff, give back.
Yeah, basically. You should basically like, I, woman, Jesse, claim trespass on my property. There you go. The wrongdoers trespass upon my property. That was a lawsuit. And that's it. Now, all I want to hear from you, not you, Jesse, when you say when you take it to a trial by jury, all I want to hear from you, lady, on the witness stand, the 20 people that just did this to me, administrated without any right, all I want to hear is yes or no. Did you or did you not trespass upon my property? Yes or no. That's all I want to hear. I don't want to hear why. I don't want to hear what excuse did you or did you not. And then you could explain to the jury why you thought you could do what you did. But I'm telling you right now, jury, they had no right to do what they did. So, yes or no, did you or did you not rob me of my property, forcibly, in front of my face? Yes or no? That's all I want to hear. I don't want to hear, well, maybe the answer in court is yes or no. And they got 3 seconds to answer that. But failure to answer is acquiescence to the wrong. There you go. And that's what you tell the jury. Watch this, jury. They got 3 seconds to answer. 3 seconds to answer. The judge knows this is true. The man in the black robe knows this is true. You got 3 seconds, man. One more time. Did you not trespass upon my property and rob me of my property? 3 seconds is done, jury. Take that as a yes. Well, I'm done. Now, jury, give me back my verdict. Give me my verdict. There you go. Render your verdict in my favor. I'm done. That's how fast the lawsuit is. So, they said that now, remember that part? I said, do not accept their, what was that paperwork they were trying to give you for like a week or two? And I said, no, don't touch it. Don't take it.
The disclosure.
Okay. Explain to people what a disclosure is.
Well, a disclosure is every single little note, little nuance, little conversation that they had with us, our kids, our family, our friends, every little piece of information they could twist to use against us in any possible way. And it was at least a good 6 inches. It's got to be even more than 6 inches thick now that I'm looking at it. But
this is what people would call like evidence that they were going to use against you, right?
Exactly. That's what they had. That was their ironclad case against us right there.
Do you remember me getting very young? And I'm not adamant about do not touch that thing.
That's right. I don't care if they don't want you to sign for it. Don't even take it because that's contracting no matter what you do.
And do you know why? If you did that, you know what they were doing? Honestly, they were giving you a red herring. What they were doing is they were going to make you waste your life reading all that nonsense. They try to keep you from concentrating on your claim. Exactly. You were going to answer their bull, which has no standing in court, in a common law court. It has standing in their administrative court, that's right. Now, if you want to waste your time and get really upset, say, I never did that to my baby. I never blew smoke in her face. I never drank and drive. I don't. Who's making up these lies? And they're going to wrap you up like a rubber band until you snap. That's why they want you to get this. It's like, I don't give a damn what the other side says. I don't give a damn what their evidence is because they're on an administrative side. All that stuff is going to be inadmissible on a common law side.
Yeah.
Nobody's going to be able to verify it. Nobody's going to be able to verify that 6 inches of bull. So when you said to the prosecutor, may I please have, go ahead, you can explain.
So yeah, once this was done, we went down to the prosecutor's office and he saw us and he's like, oh, good grief, what now? and we came and we shook his hand and we're like, good game and no hard feelings and come back with the kids and you'll get to meet them. But we're just here to pick up that full disclosure. And he just looked at us and he said, oh, crap, this isn't over, is it?
Now,
curious to see what the other side has to say.
Now, why did you want the full disclosure? Now, I think you forgot to tell the people what happens with your kids now.
Well, now our kids are going to be coming home on next Friday. We are waiting for an order to arrive. They didn't make us sign anything, so far anyway. They're pretty used to us not signing anything by now. The judge is supposed to send the order out to have the kids returned for Friday, so we've gotten all prepared and we still know that we're not done with them. They're going to be up our butts. They're likely going to have conditions and they're likely going to try to keep their foot in the door somehow, but we're just trying to get our kids out of their clutches and have our healing time and get back on our feet and then our exes are on our side, so we will be hiding them out and we'll be coming back out to nail them.
There you go. So see, folks, like I said, Jessie's doing good. She's tenacious, which is great. I mean, how old are you, Jessie?
I'm 37.
There you go, folks. So see, you don't have to be super old, but it does help to have a little bit of age on your side. So if you folks like, who get, some of their kids get taken when they're 20 years old, they're not going to be able to do what Jessie did. You're going to need somebody older to keep you calm and keep you focused because you're going to, like I said.
You're going to want to snap like a rubber band.
Right, because that's what they were trying to do with the 6 pages of nonsense. They were 6 inch thick of.
Oh yeah, once we read it, it's a really good thing we never picked that up because it was, I think it was so full of garbage. It was unbelievable.
And you would have spent how many hours you probably would have just read that thing. When you were on the wrong side of the court, it would have really wrapped your brain around nonsense that you had, look, just concentrate on this. Just focus.
Exactly. It would have just been the wrong distraction.
Right. Just get these people to know that you mean business. You're going to follow through with this claim. You robbed my kids. You know, that you robbed me. I don't care why you robbed my children. I don't care the excuse. I don't want to know why. I'm not looking through 6 inches of paperwork why the man raped me. Because I was dressed provocatively, or because I was out after 10 o'clock, or because I was driving home alone. I don't care the 6 inches of defense that this guy's going to use to rape me. I don't care. All I'm doing is making my claim, and the claim is now coming in this court. You robbed me. And I'm not only want my property back. If you don't do it by X number of days, I'm going to demand compensation for every day. How much should we put in? Like $500 a day or something, $1,000 a day?
We had $1,000 a day, yeah.
That your children are returned by X day. That it better be returned by this day. So we'll worry about compensation later. Let's just get your kids back. Just be glad that everything worked out lovely. They're terrified of you now, that they don't think you're a freaking joke.
That's right.
And we'll concentrate on, once you get the kids back, then we'll worry about compensation.